Good afternoon, everyone. Sorry for today's delay and welcome to today's Care Connection webinar. My name is Susan Shipman and I'm a social worker here at the Alzheimer Foundation of America. I am very pleased to be able to have today's guest speaker, Dr. Sanford Finkel. We often see stories in the media about undue influencing involving large estates of millionaires, but anyone can be a target who has a major neurocognitive disorder, such as Alzheimer's. Dr. Finkel will share what can happen when someone contests a will and other legal documents executed by a person with Alzheimer's disease or another neurocognitive disorder. But before we start today's Care Connection, I'd like to go over a few housekeeping items. All the lines are muted, but we welcome any questions, so please feel free to use the question box on your screen to type in any questions you may have. If there is time, we'll have a brief Q&A at the end of the presentation. Any questions you have for the Alzheimer Foundation of America, I will send you the helpline and the email address for us. Additionally, I'll be providing Dr. Finkel's information and presentation later in a wrap-up email. Dr. Sanford Finkel, MD, is a clinical professor of psychiatry at the University of Chicago Medical School. He has over 30 years experience as an expert consultant and witness in contested wills. Previously, he was a professor of psychiatry, neurology, and internal medicine at Northwestern University Medical School. He has been a long-time member of AFA's Scientific, Medical, and Memory Screening Advisory Board. Dr. Finkel has been an active clinician in geriatric psychiatry for over 55 years and maintains an active clinical practice. He continues to teach and has published over 150 articles and book chapters and delivered over 1,100 lectures, mostly on cognitive impairment and dementing illnesses. He has been instrumental in setting up programs in Alzheimer's disease in multiple countries, including Japan, Israel, and Iran. He has played a leadership role in mental health and aging throughout his career. Dr. Finkel founded the American Association for Geriatric Psychiatry and co-founded the International Psychogeriatric Association and the American Psychiatric Association Council on Aging. He is the founder of the International Psychogeriatric Association's Task Force on Testamentary Capacity and Undue Influence. And now I'll turn the talk over to Sanford Finkel. Welcome, Dr. Finkel.
Thank you so much for the wonderful introduction. I'm very happy to have this opportunity. I've been involved with AFA for over a decade, a wonderful, innovative organization when it comes to caregivers and, of course, people who have neurocognitive disorders, as well as from a scientific standpoint and from a social standpoint. So I'm very happy to be here to talk about an area where I have been involved for about 35 years, having to do with undue influence. And we're going to be talking about undue influence as it applies to people who do have dementing illnesses, neurocognitive disorders, as it's called now. But also there are times when people die and they're accused of having neurocognitive disorders when they don't. So we're going to talk about both aspects of that in this presentation. This is undue influence, where a person can be very, very nice. You see the nice hugging going on, and something else is going on that's not so nice. So I'm going to talk a little bit of my background already has been covered by Susan, but I'm going to answer a few of these questions. I get asked, well, you're talking about, you've been working with live people for 55 years. Why are you working now with dead people? Dead people were alive. And just like people with neurocognitive disorders who are no longer able to manage their finances and health, even though they may be, from a legal standpoint, considered dead, they still are alive and their needs need to be taken care of. Similarly, once people die, they have made a decision when they've been alive, and that the decision needs to be respected, unless in some ways they have been influenced, or they don't have capacity, or they've been influenced in a negative way. Whose wills are being challenged by whom? Well, most of the cases I have, or the most significant proportion, are sibling against sibling. The second most are second wives or third wives against first children of first marriages, and then you have professional caregivers as well. We're going to talk about these in more detail. terms of the requirements to execute a will, what undue influence is, the role of an expert witness, the role of dementing illness, and then, of course, whether there is undue influence or not. My background has already been covered. I've worked in many diverse clinical settings. So we are living longer in general. We've been living longer in the United States. In 1900, the average age when a child was born could expect to live 46 years, he or she. And by 2020, it was up to 80. It's actually going down a little bit with COVID, but hopefully that's just temporary. And as we look to 2058, a child born can expect to be 90 years, live to 90 years of age. As Woody Allen says, I recently turned 60, practically a third of my life is over. A great amount of wealth is going to transfer. What we know is that the baby boomer generation, which is coming of age at this point in time, a third of them are pretty well off. They have money to leave beyond their daily needs for the rest of their lives. About a third can manage their own needs, but do not have a lot left over. About a third have financial problems, and those will increase with longevity. The amount of assets that are being transferred, $56 trillion. I didn't put all the zeros in, but that's a lot of money. Often we think of investments as cash and those types of investments, stocks and bonds, but homes, real estate, farmland, some of which have oil and mineral, artwork. And it becomes more complicated in terms of wills because a number of family members may move to different states, not have as much contact with the older generation, and that will sometimes become an issue when it comes to will making. And then, of course, we have increasing levels of dementing illnesses in our society, and people who develop these illnesses sometimes forget their autobiography. There may be somebody, a sibling, for example, or a child who they've been on the outs with for decades, who comes back in after they have Alzheimer's disease, let's say, and winds up becoming very, very influential. And the whole last 40 years got kind of dissolved into a moment in the current time. Will, we've talked about, it's a written instrument. It's a legal instrument. A person makes a disposition. How do they want to leave their estate? And you do not need a lot of capacity, a lot of ability to make a decision, to make a will. You have to know that you're making a will and you're having an idea of how you want to distribute your assets. You need to know the natural recipients and their relationship. And sometimes with Alzheimer's disease, a child who has been very dear for the entire life of the child and who continues to be important, but somehow they may get left out of a will by a second wife who just came on or a caregiver that just came on the scene. And it's as if the person has forgotten what their relationship was with that very valued daughter or son. The person has to have a general idea of what their assets are. They don't have to know they have $3.25 million or whatever, as opposed to 3.8 million. But I have had situations where somebody told me they had $1 million when they had 10 million. And I had a situation when somebody said they had 10 million when they had 1 million. That's not knowing the nature and extent of your assets. Oftentimes people fight about money. Yes, that's an issue. But oftentimes they fight about love. Who is the favored sibling? Who did more for the parent? We'll get into that a little bit more later. And the person who's executing the will, signing the will basically, they must be able to keep all this information in their mind at the same time. They could be able to say, I have 3 kids. I want to leave them my $400,000 estate divided evenly. That's what I want to do. I mean, that's somebody that has a testamentary capacity. And a person needs to have the capacity to know. If they have a lot of money, I've had several cases of billionaires. They may not know everything they have, but they have to know how to obtain it. They say, well, this is how I obtain it. This is approximately what I have, but I need to be able to obtain it. These are the things I go to that will tell me what I have. So I do know the nature and extent of my estate. So you can have testamentary capacity, even though other people may basically perceive you as being eccentric, or bizarre, having weird ideas, being part of a cult, even having medical conditions which may occasionally have some confusion associated with them, but not always, maybe very physically feeble, but they still can have testamentary capacity. You do not need a lot to have testamentary capacity. In fact, I've had situations where people have been declared by the judge incompetent. They cannot manage their finances, cannot manage their health care, but yet can have testamentary capacity. A person can be psychotic and have delusions and still have testamentary capacity. A person can believe, for example, a farmer, that God is poisoning the water and killing the cattle, but still know the fact he's got 2 children and he's got a farm and some cash and he wants to leave it to them. So a person could be psychotic and still have testamentary capacity in certain situations. If they're psychotic, paranoid about a beloved child and therefore disinheriting them, that's a different story. Then they may not have capacity. When we try to figure out whether a person has testamentary capacity or not, is if they have Alzheimer's disease, is the level of complexity. If the will is very complicated, it would be hard even for a layperson to understand that had no cognitive problems. It would be very hard for somebody with Alzheimer's disease to understand that nature of their assets. And it also depends on the stage of the illness. Very early on in Alzheimer's disease, a person will have more capacity, more possibility of having testamentary capacity. Obviously, as the illness progresses and their memory and cognitive function continues to decrease, they do not have that. Now, the other thing about testamentary capacity and will contests, a person may have testamentary capacity, but a will could be overturned because of undue influence. And that's not unusual. And judges or juries may do that because, again, for testamentary capacity, you do not need a lot of capacity, a lot of ability to figure things out. But you may be influenced whether you have Alzheimer's disease or not. Here are the types of situations we run into that are common with challenges. If people have left substantial funds to people they've met recently, particularly professional caregivers or friends, they're more likely to have their wills challenged. We mentioned about siblings and spouses, faraway blood relatives with little contact, sometimes long-term partners, but not married. Charities, a number of times people will leave money to charities that can be contested, or they'll have left money to charities and suddenly a caregiver comes in and and all of a sudden they get the money and the charities get nothing. So these are situations that I've been involved with. If a person is leaving something that's making one of the family members very unhappy and feels they're entitled, well, sometimes a will be challenged. If a person has a limited amount of money, they do have assets, but they're spending down, they're buying a new car every few months, they're going on $100,000 vacations multiple times a year, sometimes a person who is an heir will have problems with that and say that there's something wrong with them. If a person refuses a medical situation that could prolong their life is another situation that comes up. Well, the person really didn't know what they were doing. And we have in the United States 2 very important principles, one autonomy and one protection. Autonomy is a person has the right to make a decision. We feel very strongly about that in this country. But people who are vulnerable also have the right to be protected. And particularly when it comes to something like Alzheimer's disease, when does a person have autonomy and when do they need to be protected from making decisions that are deleterious to them? Here's a common type of example of the Trixie syndrome, it's called in the literature. 85-year-old man with a 42-year-old girlfriend. Is he crazy? I mean, I've been asked that, by the way, in deposition. And sometimes even younger women. We know the case of Groucho Marx. It wasn't so much his estate, but he left a lot of his legacy financially to a younger woman who he was involved with. That wound up in court for many years. There was another case I had in which a piano teacher who had never married, a woman in her mid-80s, and one of her piano students was a young man who was in his 30s. And he would have lessons twice a week. They would go to concerts together. Sometimes they would have dinner together. She had distant relatives, but no one nearby. And at one point in time, she decided to make out a will. She had never done any investing herself, but when IBM became a stock, her parents bought it and did very well. And she left him his stock. So those types of situations happen. And the lawyer testified she knew absolutely what she was doing. She knew what stock she had. She knew who her family members were, but she had no contact with them. And she had a very special relationship with him and wanted him to have the information. Now, not all influence is undue influence. And we'll get to what that is shortly. But these are some of the things I've heard through the years. Honey, you promised me the house. We got married. You promised me the house. We've been married 5 years. You still haven't put the house in my name. That in and of itself is not undue influence. It is influence, but it's not undue influence. And again, we'll get to that in more detail shortly. Here's another one I've heard. Mother, I've been the one who's dedicated my life to you. I really deserve more than my brothers and sisters who've gone their own way and had their own lives. And this is a situation where a woman has had 5 children and has left everything equally. And this is what one daughter said to her mother. Another daughter said, I am the sick one to the father. I am the sick one. My siblings are financially successful. I deserve more. Next, you love us all equally. Just because she is sick doesn't mean she should get more. So these are all in and of themselves not evidence of undue influence. They're evidence of influence, but not undue influence. So what is undue influence? Undue influence is a nature, it destroys what the person really wants. It's not like the person can make one decision or another and he's taking input from somebody. It really is that that person wants to do something and someone else is trying to interfere. Sign the will or else. It's a legal term that refers to excessive or inappropriate manipulation in which a person or institution takes advantage of somebody weaker, using deception to gain assets without the true consent of the victim. And a person can be a perpetrator of undue influence by being very kind. I'm really trying to help you. I think it's not good for you to get together with my sibling, your other child. And so I'm going to protect you, but I'm going to be putting up alarms and putting up all kinds of ways where they can't contact you anymore. That's undue influence. And sometimes under the guise of guidance, I'm really trying to help you. Particularly, this is important in people that do have neurocognitive disorders. You very rarely have a situation where somebody has a gun to one's head. So undue influence in and of itself, you often can't tell right off the bat. You have to look at what the inferences are. Sometimes information is concealed. Medical information is concealed. One sibling is trying to call the parent, but the parent has a caregiver who's told not to answer the phone when that person calls. And they misrepresent the facts. Your son never calls you. I'm here with you all the time. I call you all the time. I've hired caregivers for you, but your son really doesn't care. So there's derogation. And this happens fairly commonly in undue influence cases. So it may seem that the person is acting on their own will. For example, a child who has isolated the parent and then brings in their own attorney to make a will. And the attorney comes in, well, my one son doesn't visit me. He doesn't care about me. He doesn't love me. I can't make calls anymore, but he doesn't make calls. And because of that, my daughter does everything. She brings me food. She gets me caregivers. I'm going to give her my entire $10 million estate. I used to split it, but I'm not going to anymore. Oftentimes, the influence is with a new attorney, often one known by the so-called perpetrator of undue influence, not the attorney that was involved through decades and knows the person very well. Suddenly, they're out of the situation altogether, and someone new has come in. Now, when we talk about testamentary capacity, it's really whether somebody has capacity at the moment that they sign the testamentary document, the will or the trust. Same. So if they are delirious, we talked about that a year ago, and they have an acute confusional state, they may not be able to execute a will during the time when they're delirious, but when they're not and they're in a quiescent state, then they are. So it really depends on the moment. Undue influence is a process. It's usually gradual. It happens over time. Not unusual for, let's say, a long-term girlfriend who hasn't been married and everything's gone to the 4 children. And then along the way, husband, not the husband yet, but he gets Alzheimer's disease. Then she's down for the kids get, let's say, a third, a quarter, and she gets a quarter. Then they get married. And after they get married, she gets 40%. A few months later, 70%. A year later, 100%. So it's a process that goes on over time. A person has to be kind of worked over. Now, there's something in the law called a presumption of undue influence. The definition varies from state to state. But let's say that children are accusing the second wife of undue influence. And the person with undue influence has to show that and there's the presumption of undue influence if the person had the opportunity, if they had a confidential relationship, and if there was a profit. So if somebody had the opportunity, and usually if somebody is saying, well, children are saying the second wife, she unduly influenced, and then you've got to show that there was an opportunity, a confidential relationship, or a profit to have a presumption of undue influence. And sometimes the presumption may go back and forth, but even if there's a presumption, that doesn't mean there was or was undue influence when it's determined by the court, by the judge or jury. But it does change the burden of proof. I've written and published on the indicia of undue influence. Indicia means signs. Now, having signs in and of itself does not mean that there was undue influence, but it does mean there's suspicion of undue influence, and you need to look at the matter very, very carefully. Vulnerability, of course, is extremely important. Mental vulnerability, and of course, we're talking about neurocognitive disorders often, but people may have depression, people may have psychosis, other mental illnesses, and so there also may be physical limitations, but those are usually less paramount. Where it's paramount is not so much a person needs a wheelchair, but the person that needs a wheelchair is dependent on the person they're giving their money to. That's why we talk about physical vulnerability in that regard. Dependence, and again, this is an extension of what I just talked about, dependence on the person who is accused of perpetrating undue influence. Often they're responsible for the money, they're responsible for caregiving, responsible for the driving, responsible for the laundry, responsible for food, responsible for social. And the more dependence, the more one is suspicious that there is or could be undue influence. Sequestration, probably at the top of the list, actually. Sequestration means isolation, where people that ordinarily had a relationship with the person that is making the will, they suddenly are eliminated. And they can be eliminated physically. They can be eliminated sometimes because the person has hearing problems and can't hear. They can be eliminated because they do not have critical medical information that they would want to have and might have an impact in terms of decision making. But sequestration and dependence and mental vulnerability are at the top of indicia that we look at when we try to evaluate undue influence. Procurement of the will. We talked about this, whether the person who is benefiting from the will has a lawyer that's a friend of theirs or to go to. Again, it may not be in and of itself the conclusions there was undue influence, but it is a concern. The person being accused usually has profit, they gain from it. They may have inclination, there may be evidence. Well, the second wife didn't like the children, or the brother didn't like the sister, and he did everything possible to turn mother against her. And sometimes there's strong evidence that there's a disposition or an inclination to do this. Emotional manipulation, and again, where there's derogation. Your son really is a terrible person, daughter might say. He's done horrible things through the years. You've tolerated him, but he's really a bad person. and try to manipulate the mother or the father to see things in a different way. Suspicious circumstance, all of a sudden, the will is changed, like very hastily, under unusual circumstances. Again, in and of itself doesn't mean there was undue influence, but it is one of the indicia we look at. Is the will consistent, or is it inconsistent with what the person has wanted through their lifetime? Is it unnatural? I gave an example earlier of a father who is very, very close with a daughter. A woman comes in who we hadn't seen, and then there's a marriage, and all of a sudden the daughter is left out of the will altogether, and the second wife gets everything, second wife of a few months. That would be considered unnatural. And opportunity. Did the person have the opportunity to influence their father or mother to change the will? There are other considerations. Terminal illness. Sometimes people are on their deathbed. I've had a number of situations where people have been on their deathbed. They've had a certain disposition they wanted. And then while they're getting advanced chemo and actually they only have days to live, somebody comes in. It may be a friend of a boyfriend, for example, that's one case I had, and comes in with a will and has the woman as she's dying sign it. That's an example of undue influence. A person's personality, a lot of people are somewhat passive and they can be influenced very easily throughout their life. Some people are very stubborn. It doesn't mean they can't be influenced under certain circumstances, but if you have somebody that's suspicious of everybody and won't do anything that anybody wants, then they're unlikely to change their will because somebody's asking them. Doesn't mean it can never happen, but it's less likely. I mean, if the person won't even trust their children to go to a doctor, if they come in to change a will, they're less likely to do it if they have a paranoid or highly suspicious tendency. Substance abuse, people who have been using drugs, I mean, we see that not as much in very, very elderly. We do see benzodiazepines, which can affect cognition in some people, but you also have some people, even older people, who are on cocaine, and that can impact their frontal lobe and result in their judgment being impaired. Family conflict, I mean, this is a context in which undue influence is most likely to happen, as both parties or all parties may be tugging on the parent to change a will in their favor. And then radical change, where somebody is making a completely different change. One recent case, a family was getting everything, and then the person met somebody and became a friend, and then the family got nothing. Over a period of several months, things changed. That's a radical change. Again, it's an indicia of undue influence. Does it mean in and of itself there was? No, but it lends itself to the increased possibility there was. Usually when I review cases, I ask for prior wills. What is the person wanted through the years? And if they've made changes, what were the circumstances under which they made the changes? It's important when I evaluate live people as to whether or not they have testamentary capacity, that I give them questions that are open-ended. I can't tell you how many times I've seen lawyers videotape or audio tape, and they think that, oh, well, if I do this, it'll show the person had capacity, okay? And they'll say, well, one case I remember very well, well, today's July 8th, 2012, isn't it? Yes. Yes. Well, we learned to say yes and no, like by the age of 2 anyway. Yes, no, but it doesn't really give the answer. And in this particular case, that woman had been seen by a psychiatrist 4 days before. And instead of thinking it was July 2012, she had said it was December 1896. So obviously she was disoriented. But if you ask yes or no, you really want to leave your estate to your son who loves you very much, as opposed to your daughter who really is a terrible person, right? Yes. Okay. See? So I'm telling you things that I have actually seen on videotape or heard on audio tape, where the lawyer feels that this is evidence that shows that his client or her client has testamentary capacity and there's no undue influence. Now, of course, we want, as a psychiatrist reviewing will contest, I look at things like orientation, memory, judgment, insight, behavior, all types of mental status evaluation. And I derive this mostly from the medical charts, but also from fact witness depositions and from affidavits, because oftentimes there are people that have contact with these people who have very good insight. And they also notice when there's a difference. A recent case, there was a question of when this man, who was very, very smart, but had developed Alzheimer's disease, couldn't make financial decisions. Well, his broker basically said, this was one of the smartest guys that I have ever worked with. He was usually asking questions, making recommendations. And then in the last couple of years that I worked with him, he couldn't make a decision on anything. Somebody else was on the phone with him, trying to convince him to do something, and then he couldn't figure it out. We'd ask repeatedly. And subsequent to this, this man made a change that was, and we were talking about the $10 million, a change in his estate, and he definitely had some significant cognitive impairment. And again, these are some of the things, if we look at our diagnostic statistical manual, these are some of the things that we look at. Attention, whether a person can focus, social cognition, does a person understand his relationships with other people, learning and memory, can a person remember, can they integrate what you're telling them and remember it a minute later even, perceptual motor skills, can they visually integrate information, language, can they communicate effectively what we think they want to communicate, and can they understand what you're telling them? And executive function. Executive function is like being your own CEO. It basically means that you are in charge of yourself and making decisions. You can see what choices are available to you. You can weigh the pros and cons of the various choices. You can manipulate information, and then you can make a decision based on your appreciation of the facts, your understanding of your choices, your ability to look at what happens if I do this, what happens if I do that, and then make a choice. Oftentimes in will contests, I'll be presented with, well, the person said yes. Goes back, person could say yes at the age of 2. It depends on how things are presented. This is what you want. I just read it to you. This is what you want, isn't it? Yes. It's not, well, tell me what it is you want. That's an open-ended question. That's what it's important to obtain. As psychiatrists, when I'm evaluating people as to whether or not they have testamentary capacity, these are the questions I ask. And if you change the will around, how is that going to affect your relationships with people? I go beyond maybe what's totally necessary from a legal standpoint. But on the other hand, some lawyers will use this information, some will not. Some have formal training, some have not. Some have experience, some have not. So it's not the same as an expert in the mental health field who basically has a structure of the kinds of questions to ask that may go beyond yes, no questions. Okay, so the expert witness. I think we talked about the fact that it's not always about, I can tell you many situations where both sides lose from a financial standpoint, but it's a matter of who's right and who's wrong, who's loved more, who's loved less. And I've seen situations where they've been ridiculous. Both sides wind up losing more than they would have if they'd won, if they had just settled originally. I'm also often presented with attorneys by, well, Dr. Finkel, this is just a fact. Everybody knows the fact. Everybody knows that he executed a will on this particular day. You're saying that everybody can know that. Yes, but it's how you interpret it based on medical information. And what medical information do I have about the person's capacity at that point in time? Similarly with undue influence, what evidence is there that undue influence has taken place? There is a literature in our field on undue influence by the International Psychogeriatric Association, by a task force from California, by other people who've written through the years in prestigious journals. So we do have literature. And years ago, judges were asked in one study whether having an expert was helpful in understanding undue influence. And the considerable majority that responded said yes. I get this all the time, but you've never seen the patient, okay? Dr. Finkel, how can you express opinion? You've never seen the patient. If you have that philosophy in general, somebody like Chernow, who wrote Hamilton, brilliant book, or these people that write about Churchill, 1,000 pages. They've never met these people. How are they going to be an expert? Why listen to anything they have to say? Because this is part of what they've done. They're historians, and they have done history, and they know how to document. They know how to do research. And so oftentimes, I'll be told, well, Dr. So-and-so is the primary care doc and has been for 4 years. And he's seen this patient 12 times. And you're saying you know more than he does about whether or not there was undue influence or testamentary capacity? Well, the 12 appointments, if they're 20 minutes, that equals 4 hours. During the 4 hours over the lifetime, some of it is in physical exam, listening to the heart and the lungs and doing all the other stuff. Some of it is chit-chatting and how's the family. Very rarely do you get a cognitive assessment beyond kind of general conversation. So somebody that has very, very little information about the person's mental health, as opposed to in a will contest, I wind up not only reviewing the primary care physician's records, but the prior primary care physician's records, by all the specialty medical records, by the physical therapist and occupational therapist records, by the testamentary documents themselves, by the depositions where people are giving facts about their experience with people, about affidavits, about financial information, whether the person was able to write checks or not. So I have, it's maybe sometimes 100, 200, 300, sometimes 400 hours that I'll spend on a given case, depending how much information there is. The 400 hours is pretty comprehensive. You compare it to 4 hours where maybe the person's in conversation with 2 hours over the person's lifetime. Of course, I have more information, but it does come up periodically. You haven't seen the patient. The vast majority of will contests that occur in the United States where there's an expert witness, the expert witness is allowed to opine because that's what they do. They take the facts of the case and they take their expertise and they put the two together. So on the other hand, you may have a judge, once said a great while, who says, well, yeah, that's okay. And the jury unanimously says, you're right, Dr. Finkel, but I don't agree. So, we're going to eliminate that. The primary care physician knows best. Rare indeed, about this particular thing. Cultural and religious beliefs, don't have a lot of time to get into that, but it can play a role. I've had people of Orthodox Jewish religion who've disinherited children because they've married out of the religion. In certain cultures, traditional Korean cultures, for example, oftentimes the elder son is treated preferentially, sometimes exclusively. So all of those need to be taken into consideration when looking at a will contest. I discourage lawyers from working with a family member alone. And you think, well, that probably doesn't happen, but it does happen. Sometimes the older person who's signing the will may be there, but the person that's really there all the time is the person that now is going to be getting most of the money at their family member's expense. And so that happens much more than one would anticipate, but it does happen. We talked about love and sibling rivalry. Okay, how do I get challenged? Credentials, well, with 55 years of experience as a geriatric psychiatrist and 35 years doing will contests, that doesn't happen very often when they look at my credentials. The methodology is very common. In the old days, you could say, well, I've got a lot of experience and therefore I know what I'm talking about. That gets thrown out. You've got to show either from the literature, the professional literature, that this is part of what the literature says, or you have to demonstrate that this is what's generally accepted in your field. And those, otherwise you're going to get challenged and you could get thrown off a case. We talk about looking at the facts of the case, take an enormous amount of time. Usually by the time of deposition and trial, I know the facts pretty well. I've gone over them multiple times. I challenge sometimes clinically, not unless there's another expert on the other side who says that they know better than I do, and then the judge or jury is going to have to decide. The science, what the literature shows, forensic, how testamentary capacity is defined is pretty similar from state to state, although in Missouri, for example, besides the usual criteria, you also have to understand the ordinary affairs of life, whatever that means, not well defined. On the other hand, with undue influence, there's a great deal of difference. I could not testify on this in California because of their criteria. And if somebody coming from California, this is a case going on now, and they're applying the California criteria. Well, that doesn't apply in Illinois. So you have to know what the criteria are in the state. The most common accusation I get is one of bias, either because I've spent so many hours that I've run up a bill. And so, well, you run up so much money, therefore you're biased. Well, but there are a lot of cases I turn down because I don't think I'm going to be on the right side of the case from the lawyer's standpoint. There are a lot of cases I review information and I tell the lawyer, I wish I were on the other side. I don't think you got much of a case. But bias is very common. That's probably the number one area where they try to say, or let's say in a report, there are 200 examples on one side and 200 examples on the other side. I think the 200 on one side are more important for reasons that I give, but I only list 60 and 60. And the other attorney on the other side, well, you didn't list this one, you didn't list that one. So even though I give an excellent representation of both sides, and you have to present both sides of the case when you have your initial information. And then in the discussion, you talk about why you will weigh one side more than the other because of clinical, because of science, or other reasons. What's my role? Teach, teach, teach. That's what you do. You're not there to win cases. That's the lawyer's job. You're there to teach. I've been a teacher. I'm a professional musician. From the time I was an adolescent, I was teaching my classmates piano. So that's what you do. You teach so the jury, or the judge, the other attorneys, as well as your own attorneys, can learn. That's part of what's joyful, and that's why I still continue to teach. Again, these are some of the things an expert witness has to have. They have to have skills based on experience and education. They have to have knowledge. They have to have been trained. And again, they have to be able to interpret the facts and look at the totality of a situation. Many times, I will see 90% of information going in one direction, but you have a few things in the other direction. And of course, the other attorney is obligated to take, well, what about this? What about that? And the answer to that is, okay, but you look at the totality. If 90% is on one side and 10%, then with a reasonable degree of medical certainty, which is the term we use, then this is my opinion and why. Dementing illness, of course, very important. Early dementia, it unduly influence requires more persuasion, but as the illness progresses, you need less and less and less. People who lose spouses, they're lonely. Sometimes they're fearful of abandonment from a second spouse. Sexual favors can play a role. Yeah, it definitely does. And then you also have to be aware of what the illness is. With all Alzheimer's disease, loss of recent memory is paramount. But frontal lobe dementia, it's a different part of the brain, and your recent memory in the early stages may be pretty good. And people around you may not know you've got frontal lobe dementia because you're able to remember certain things, and you may be able to have testamentary capacity. But with frontal lobe dementia, even much worse than Alzheimer's, your social cognition is impaired and your executive function is impaired. Executive function, again, ability to make decisions. You do not make logical decisions anymore, anywhere near the same extent as before the frontal lobe dementia. And social cognition, your understanding of relationships diminishes. Who's friend, who's foe, who's taking advantage of you, who loves you, all of that gets mishmashed. So you have to understand what illness you're dealing with. Now, ordinarily, if a person doesn't have testamentary capacity, they cannot be unduly influenced. But again, it depends on the judge. Judge can say, well, maybe they do, maybe they don't, but it's up to the judge, really. My first case was a prominent individual in his 90s, challenged his will by his favorite son, who was left out of his will. The guy had $40 million. He kept a diary for the last 77 years of his life, till he was 95. He had testamentary capacity, but there was undue influence. The judge was unhappy about the case, threw it out, but he accepted my report, which said that there was undue influence. Eventually, it went to the appellate court and then the Supreme Court of Illinois. They said, based on my report and a couple of other things, that it had to go back to trial and that there was a reason to debate it. So it took 12 years from the time the guy died to the time the matter was settled. It never did go to trial. And I'll give you a couple of cases in conclusion here. Mr. Jones, and this is, by the way, a combination of several cases, because these cases actually were all settled, almost all. And if they're settled, you really can't talk about them there's some confidentiality rules. It's different if it's an open court where there's a trial. But anyway, this man worked for 35, he had a home office, he had an assistant, there was one daughter, son lived out of the country. Then he started to forget to pay his bills. And the person that was working for him, the secretary, became his power of attorney. The daughter did take the father to a neurologist, says he's got Alzheimer's disease. But the next thing we know, he's taking, the daughter is finding female underwear in his bedroom and finds that the secretary is now driving a top-of-the-line BMW. She becomes angry and wants to fire the woman, but the father refuses. And then what happens is she tries to consult the lawyer, but she gets cancer, and therefore she can't really proceed. She requires intensive treatment, and the son really can't come in. And Jane has a brother-in-law who basically is an estate planning attorney, and he continues to deteriorate. And as he deteriorates, the children get less and less. Finally, the daughter gets 10%, the son 40%, and the secretary gets the rest. And this is a combination of different cases that I've had where this happens. Okay, let's move on. So here are some of the indicia. There was conflict. There was a procurement of the will, as the secretary had a brother-in-law who was a lawyer, did it. She profited. He was vulnerable. There was isolation, as the children couldn't visit. And she basically said to the father, the children are too ill to visit. There was dependence on the secretary, emotional manipulation. It's a confidential relationship, and probably sexual favors. Now, case 2 I can tell you about because this was a live case this year in Utah. And this is a 97-year-old woman who changed her will while in the hospital recovering from hip surgery. She had had a stroke 2 years before, which left her blind on one side of her body. So she really couldn't see on one side. But she still was okay, but went into assisted living, not in the memory part, but assisted living, was doing very well. But after she had her stroke, she was recovering in the hospital. She had 5 children, all loving, wonderful children, all involved with her. All 5 agreed that all of the children loved her and were involved with her. Her husband had died 15 years before, and she made a trust then. And she wanted all of her children at the lawyer's office to make this trust. In the trust, she had a farm, she had cash, and she had recreational property. And she said, I want to leave everything equally to all of them because I love them all equally, and they're all wonderful children. 4 of the children were fine. One son felt, well, you know, I go to the recreational property more than anybody else, so I really deserve it. And 8 months, but she goes, she executes the will, everything's equal. 8 months later, he takes her back to the lawyer, and they change the will so that he gets the recreational property. But in the meantime, the family keeps celebrating at the recreational property, and several years later, through a series of coincidences, they find out what happened. And they ask Mother, why'd you do this? You know, you love us all equally. And she said, well, you know, this son, I'm concerned about him rejecting me, and he's very upset if I don't do this. And so between that time and for the next number of years, there was friction between the son and the 4 other siblings. When Mother fractured her hip, and this is years later, she comes to the hospital. The son that inherited the property gets into a fight with some of the other kids. And Mother says, what do I do? The children used to get along. And one of the sons says, well, you know why this has happened, Mother, you know. And she says, you're damn right I know, darn right I know. I want you to fix it. I want to do it like it was before. Leave everything equally to the 5 children. So they immediately go out and bring a lawyer back, a lawyer that she knew, but a lawyer that was also friends with one of the children. And she basically changed things around to leave everything equally to the 5 children. So there was a professor from geriatric medicine that wrote a report and testified saying the woman didn't have capacity. She couldn't know who her next of kin were, and she couldn't know what her property was, and she couldn't make a disposition, leaving everything to 5 children. There was only one problem she had. She was not very thorough. All 5 of the children testified under oath, including the one that lost the property that he thought he should have, that she always knew who the children were. There was never an issue with that. She always knew she had the property. She always asked about it all the time. So then the other expert had to basically go back and say, well, okay, well, maybe that's right. I have to walk that back, basically. But she was too impaired to know that she was leaving it to her 5 children equally. And I can tell you, it's the only case I've ever had, and I've been involved with maybe 200 such cases approximately, where the problem is that somebody left something evenly to all of her children. Usually it's because there's a unequal division. And the way the lawyer won the case, the question came up, was this woman under drugs because she was on narcotics? And the lawyer in this case really was quite brilliant. What he did is he somehow found the nurse who was on duty that particular day. And actually, what the nurse said is, no, the woman wasn't on pain medicine, and she wasn't in pain either, which is what the other expert said. She wasn't on pain medicine. How do I know? I came in to give her usual 3 p.m. dose, and she said, I'm making out a will. I don't want to have any tiredness at all, so hold the medicine till 4 o'clock. So that's what the nurse basically said. And then the nurse said, when she was asked, well, how was she doing at that time? Oh, fine. She was talking to everybody. She was lucid. She and I had a conversation. We were joking around. She knew what she wanted to do. Well, again, I could be very expert in terms of my medical opinion, but having the nurse who was there and who had no bones to pick, no, they can't say she's biased because she's earning money on the case. And she had lived and moved to different places, but the lawyer found her, and bringing her into the case, when the judge wrote her opinion, she said this was an extremely important part. She also said that both I and the other expert said it was important to be thorough, but I was thorough and the other expert was not. There was no isolation here. The children could visit at all times. There was no dependency. I mean, basically, one of the daughters helped her with finances, but one of the sons that lost the property, so to speak, helped her with all kinds of other things. And she was dependent on staff help. So there wasn't a situation like we had with case 1. It wasn't unnatural to leave everything equally to 5 children. The children did procure getting a will by getting it, and they did profit because they got back on the will evenly divided. There was a confidential relationship with one of the children because she was power of attorney. There was family conflict. She had physical vulnerability. But again, the main issues, indicia of undue influence, were not there. And the judge, after several months of careful deliberation, really wrote what I thought was a brilliant summary. And the verdict was that the woman had testamentary capacity and that there was no undue influence on the part of the 4 children. So again, 1/3 of baby boomers have significant wealth. It's going to be distributed. And in the United States, people can decide how their assets are distributed. In other countries like France, you have to leave money to a spouse. You have to leave money to children. Sometimes the state, the governments determine what you leave and even how much sometimes about what you leave. That's not the United States. Although most estates are distributed without overt conflict, a growing number are contested with accusation the older person lacked testamentary capacity, was subjected to undue influence. And of course, we're especially prone to be challenged if people suffer from Alzheimer's or other dementing illness. In case number 2, the other side said, oh, she had Alzheimer's disease. She was demented. If you take a careful look at the notes, she had a cognitive screen the day after, and she was totally oriented, she was totally oriented to time, and she had good recent memory. For sure, she did not have Alzheimer's disease. And actually, she lived for another 1.5 years, and at the other place that she was at, they also called in caregivers who talked about how she talked about her program, she talked about her family. This is not a woman who ever had Alzheimer's disease. A person with dementia may have capacity and may be resistant to undue influence, depending on the complexity of the will, the stage of dementia, and other considerations. There are many indicia. The major factor is determining what the testator really wanted. Thank you, and I am delighted to answer any questions that you may have. Appreciate your attention to this area, which is only going to grow in importance in the coming years.
Thank you, Dr. Finkel. It's Susan. If you just leave that slide up with your information, that would be helpful for everybody. I will send out your information, but it's good in case anybody wants to jot it down now. We do have a general question. You mentioned significant wealth in our group of people now, and in these times where the value of a dollar has so greatly diminished, what is meant by significant wealth in 2023?
Enough money to have a court case, because these are very expensive. You have to pay for lawyers. Lawyers are very expensive, go through depositions. You don't get many will contests if the estate is $100,000, $150,000. It's rare because the legal expenses eat up the whole amount. There's nothing left for anybody. So I think probably the least amount in recent years that I've been asked to opine on is in the $500,000 range. Even there, you can wind up with both sides spending a lot of money on lawyers. It depends on how much deposition testimony. I've had cases where there have been 5 depositions of 100 pages each, and I've had cases where there have been 50 depositions, some 350 pages each. So again, that latter case was a billionaire. But, and I've had a number of cases of billionaires, 100 millions, tens of millions. Certainly, if you're looking at millions of dollars, it's usually worthwhile, depending on how much there is to review. But if you're looking at a few $100,000, rarely. You can make a big stink. You can say it's not right. You can try to represent yourself, but it's going to be very costly to do it right.
Okay. When cases are eventually decided, does a second will or an addendum to the original will need to be probated?
I mean, that's more of a legal question in terms of when something needs to be probated. That wouldn't be in my area of expertise.
Okay. One person is writing and asking, can you offer any information or advice on how to avoid some of the issues that you brought up in specific cases, to avoid undue influence, to avoid last minute wills?
That's another whole presentation. I mean, if you can resolve family conflict, if somebody will come together. There are times when I've been asked to do a testamentary and undue influence assessment on somebody, and I've said to them when they've come in, this is going to wind up possibly as a will contest. Maybe you can do A or B, or if you want, I can even help you and bring both sides together. Because even though you're angry with this side and favor this side, this can wind up eating up a lot of your estate. So sometimes you can do something prophylactically by decreasing family conflict. If somebody is clearly demented and having difficulty with decisions, better to get a guardianship if you think something like this could happen, because there's sibling rivalry, for example. And sometimes siblings and children are, well, I don't want to put my parent through it. They'll be mad at me. I don't want to have that to go to court. It's very terrible for them. But then what happens is they continue to deteriorate. They make out wills, and at some point in time, the paper has to be paid. You got to go to court then to challenge the will. So sometimes guardianships early on, but certainly resolving family conflicts would be the best thing. If you can do that, that's the best thing. And that's not easy to do when there's long-term sibling rivalry or where there's conflict with a second wife.
Where emotions run high.
Emotions run high and logic sometimes runs low.
And logic runs low, but it would be better in those cases to settle out of court.
Absolutely. Court is very, very expensive. And sometimes what happens is, and I've seen this happen, and where a lawyer had a case recently, a lawyer basically told children who were disinherited, and everything went to the children who had inherited, who were closer to the mother. And they said, you know what, this is a pretty easy case. You're going to get a lot of money. They screwed, those other children screwed you. Well, it wasn't true. And there's a lot of evidence it wasn't true. But the lawyers hadn't done a thorough enough evaluation to done their homework. So later on, when the information all became evident, I wrote my report, the lawyers who had detailed notes, things like that happen. Then you're dealt with situations as attorneys where your clients have been promised something, and now you're asking them to settle for much less. And that results in long, long delays in settlement. So that's an issue too. You got to pick a lawyer who's going to do the work up front, and you got to pay them for it. before they take on the case and know what they're talking about.
Very complex. Well, I thank you very much, Dr. Finkel, for all your insight into these complex issues surrounding legal documents and people with Alzheimer's disease and related major neurocognitive disorders. We very much appreciate you sharing your expertise with us today. And thanks to all of you again for attending this Care Connection and for your thoughtful questions. And I'll be sending an email following the webinar in the next couple of days with all the pertinent information. Before we end, I want to encourage you to sign up for our next Care Connection webinar, which will be October 2nd. And the title will be Helping People with Dementia with and Without Medications. Dr. Gary Kennedy presenting. And Dr. Kennedy is a professor and vice chair for education, director, division of geriatric psychiatry and behavioral sciences at Montefiore Medical Center, Albert Einstein School of Medicine. This is a rare opportunity to hear Dr. Kennedy speak about the various rationales for using and avoiding medications for people with dementia who are distressed. I hope to see you Monday, October 2nd at 1 p.m. Eastern Time, and take good care, all of you, till then. Dr. Finkel, thank you very much again. It was a pleasure.